Blake Lively and Ryan Reynolds are fighting back against Justin Baldoni's $400 million lawsuit as they're now trying to have the case thrown out, calling it a vengeful attempt to silence Lively after she spoke out about alleged sexual harassment. With explosive accusations, legal drama, and California's Me Too protections in play, the high-stakes clash is more than a celebrity feud. It is a battle over accountability, free speech, and the law. We're going to get into it right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Well, in a dramatic turn of events, Hollywood power couple Blake Lively and Ryan Reynolds have taken a firm stance against the film's co-star and director Justin Baldoni and his production company Wayfarer Studios. The couple has filed separate motions to dismiss the amended complaint that Baldoni filed in January, which names Lively, Reynolds, publicist Leslie Sloan, public relations company Vision PR, and the New York Times. Baldoni's lawsuit accuses Lively of conspiring with the newspaper to defame him and Wayfarer Studios, alleging that her actions are part of a calculated Machiavellian effort to seize creative control over the film. But this month, both Blake Lively and Ryan Reynolds filed motions to dismiss Justin Baldoni's $400 million lawsuit, which they described as a vengeful and rambling attempt to silence Lively and punish her for speaking out about alleged sexual harassment. And in her motion, Lively called the lawsuit, quote, a profound abuse of the legal process. So what we're going to do is we're going to get into both of these motions, and I am also going to tell you what the potential counter-arguments, potential weaknesses to their motions to dismiss will be. But first up, let's talk about it. So, Lively's legal team also cited California's recently enacted Assembly Bill 933, sometimes known as the Me Too bill. It's a reference to the movement and hashtag that brought more global attention to issues of sexual harassment and discrimination, and of course, sexual assault. Now, the bill provides critical protections for individuals reporting sexual harassment, ensuring that communications about such incidents are privileged, they're protected. And it allows those sued for defamation who make these claims after speaking out to actually recover legal fees and damages. So in their motion, Lively's team emphasized the importance of this law, stating the law prohibits weaponizing defamation lawsuits like this one to retaliate against individuals who have filed legal claims or have publicly spoken out about sexual harassment and retaliation. The right to seek legal redress and the right of the press to report on it are sacred principles that are protected by multiple privileges, including the litigation and fair report privileges, which are absolute. Now, Lively's motion also highlighted what her team sees as a glaring contradiction in Baldoni's lawsuit, that his portrayal of her as both a powerful Hollywood superstar and simultaneously powerless. The filing states, on the one hand, the Wayfarer parties insist that Miss Lively is an immensely powerful Hollywood superstar who, along with her influential husband, wielded power to steal creative control over the film. But on the other hand, they claim she was so powerless that the only way she could have any power was by manufacturing sexual harassment allegations almost a year in advance in a Machiavellian long game. These two concepts contradict each other and therefore cannot coexist. In other words, he's not telling the truth. Now, we're going to do a deeper dive into her filing in a minute, but first, I want to catch you up on the timeline here. So on Tuesday, Ryan Reynolds filed his motion to dismiss the lawsuit against him from Baldoni, arguing that there's no evidence he defamed Justin Baldoni. Instead, Reynolds described the lawsuit, quote, as a burn book filled with grievances attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the woman in his life and to hold her anguish and actually stand with her. And Reynolds argued that he was only included in this lawsuit because he's Blake Lively's husband. And his filing also addresses New York's anti-SLAPP laws, calling the lawsuit a textbook retaliatory SLAPP suit and accusing Baldoni and Wayfarer Studios of using the legal system as a, quote, blunt public relations instrument to further their smear campaign against Lively. In New York's anti-SLAPP laws, SLAPP stands for Strategic Lawsuit Against Public Participation, they are designed to protect individuals and organizations from retaliatory lawsuits aimed at silencing free speech. And then Reynolds also addressed defamation claims against him, which stem from allegations that he called Baldoni a predator during a private conversation with a talent agency executive. And his legal team argued that that statement is protected by the First Amendment, stating, calling someone a predator amounts to constitutionally protected opinion. By the way, it doesn't appear as if he's denying saying that, which is very interesting, but basically saying this is opinion, this is protected. And then Reynolds' team further pointed to Baldoni's own public admissions, including things he said in his books and on his podcast, where he allegedly discussed his past behavior with women and struggles with a pornography addiction. The filing reads, "It would be perverse to permit Mr. Baldoni to build an entire brand off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million for simply pointing out in private what Mr. Baldoni has bragged about in public." We'll get back to Ryan Reynolds in a minute, but for now, let's go back to Blake Lively's motion that was filed Thursday. So, her team doesn't hold back, and they open with a powerful characterization of Baldoni's lawsuit as a, quote, vengeful and rambling abuse of the legal process. And they argue that this lawsuit was designed to retaliate against Lively for speaking out about sexual harassment and retaliation, a move that they say the law explicitly prohibits. Why? Because they argue that Lively has the right to bring forward her claims and to speak to the press about them, and the press in turn has the right to report on such matters. Her filing states the right to seek legal redress and the right of the press to report on it are sacred principles that are protected by multiple privileges, as I mentioned before, including the litigation and fair report privileges, which are absolute. Moreover, by choosing to bring their claims under California law, the Wayfarer parties have voluntarily subjected their entire lawsuit to the sexual harassment privilege in the recently enacted California Civil Code Section 47.1, which bars retaliatory lawsuits based on public disclosures of sexual harassment and related allegations, including disclosures to the press. Given all these protections, the Wayfarer party's chief complaint that Miss Lively and others supposedly conspired with the New York Times is barred as a matter of law. She was legally entitled to file her complaint and disclose it to the public. Now, Lively's team cites California Civil Code Section 47.1, which is an extension, an addition of Assembly Bill 933, which we discussed earlier. Signed into law 2023, and it added on to California Civil Code, providing protections against retaliatory lawsuits. And it ensures, essentially, that individuals can't be accused of defamation for bringing forward allegations of sexual harassment, assault, discrimination, that they shouldn't be silenced. And Lively's team is using this to argue that she is shielded from defamation claims as a matter of law on these grounds. But that is just one of the protections that she's invoking. Another is the litigation privilege, also known as the judicial proceedings privilege, which makes sure that people involved in legal proceedings can communicate openly and freely and make legal claims in filings without fear of legal repercussions, without fear of being sued for defamation. The third is the fair reporting privilege. So that's a defense that typically protects journalists from defamation claims when they report on official proceedings or records. This is how outlets like Law&Crime can report on trials, police records, court documents, mention these allegations and accusations without risking defamation liability. And going back to Section 47.1, Lively's team is also claiming that if the lawsuit is dismissed, she could be entitled to significant compensation. The filing reads on top of that. Section 47.1 contains a mandatory fee-shifting provision that will require the Wayfarer parties to pay not only Miss Lively's attorney's fees, but also treble damages and punitive damages if and when their defamation lawsuit is dismissed. In other words, in an epic self-own, the Wayfarer parties have created more liability for themselves by their malicious efforts to sue Miss Lively into oblivion. And that means that if Lively succeeds in getting the case dismissed, she can potentially recover reasonable attorney's fees, costs from mounting her defense. And by the way, the statute allows for treble damages, triple damages, that's what it means, for any harm that was caused by the defamation claim. And punitive damages, by the way, are a way to punish the other party. So now that we've covered the protections that Lively is asserting, let's dive into the background of the case, and much of which will sound familiar if you've been following our previous episodes here on Sidebar. So what led up to Lively filing her complaint in the first place? Well, Lively's motion details several incidents of alleged sexual harassment and inappropriate behavior by Justin Baldoni and the CEO of his production company, Jamie Heath, during the production of the film It Ends With Us. And these claims include allegations that Baldoni entered Lively's trailer, criticized her appearance, filmed a simulated nude scene without an intimacy coordinator, discussed personal sexual experiences on set, had a friend play the role of a doctor in a scene where Lively's character is giving birth. And notably, Lively's team points out that Baldoni himself acknowledges many of these incidents in his first amended complaint happened, though he disputes the characterization and the context of what happened. The filing states, far from suggesting her claims are untrue, the FAC, the first amended complaint from Baldoni, while quibbling with Miss Lively's characterization of events, is full of admissions that the incidents underlying Miss Lively's sexual harassment claims occurred. Now, Lively's team argues that Baldoni's subsequent actions further support her claims. For instance, after the 2023 writer's strike, Lively allegedly presented Baldoni's team with a 17-point list of protections via email requesting that these points be agreed to before resuming filming. And according to Lively, Baldoni's team not only agreed to these terms, but also participated in an all-hands meeting before signing the document. And the filing reads, notwithstanding its purported concerns, Wayfair ultimately found the protections agreeable and signed an agreement committing to all of the terms of the protections for return to production on January 19th, 2024. On January 4th, 2024, the parties attended the agreed-to all-hands-on meeting, during which the First Amended complaint alleges that Ms. Lively read aloud a list of grievances that the Wayfair parties alleged they believed were as troubling as they were fictional. Keep that in mind. So Lively's team is essentially arguing that Baldoni's decision to allegedly sign that document is an implicit admission of the issues on set. Now, Baldoni doesn't dispute signing the document, at least it doesn't appear to, but he claims he did so out of fear of the consequences if he refused, such as losing Lively as the lead, her potentially going public with what he would claim are false allegations, damage to his reputation in the movie. So this brings us to the second key point of Lively's team that they raise, the alleged smear campaign. So according to Lively's motion, Baldoni and Wayfarer Studios panicked and launched this campaign to discredit her before her concerns would become public. And the filing states, Mr. Baldoni and Wayfarer grew increasingly fearful, desperate, and terrified that Miss Lively would publicly discuss what happened on the set of the film and decided to go on offense, engaging a team to discredit Miss Lively before her previously documented sexual harassment concerns could become public. Among the individuals who Mr. Baldoni engaged for this work were his co-plaintiffs Jennifer Abel and Melissa Nathan. In one text message between the two of them, Miss Nathan explained that they could not write "We will destroy Miss Lively" because one could only imagine if a document saying all the things that he wants ends up in the wrong hands. Miss Nathan wrote, "You know we can bury anyone." So the communications that are outlined here, allegedly between Jennifer Abel and Melissa Nathan, who were part of a crisis management team, suggest a calculated effort to manage public perception and preemptively undermine Lively's credibility. That's an argument here. That's an allegation. Now, if true, these texts paint a picture of a coordinated strategy to protect Baldoni's reputation at all costs. But now let's break down the legal standard at play here when we talk about a motion to dismiss. So, Lively's motion explains the criteria, the requirement for dismissing a complaint under the Federal Rules of Civil Procedure 12b-6, which essentially says that even if you take everything in the complaint as true, there is still no viable legal claim. The filing states, in reviewing a motion to dismiss under Federal Rules of Civil Procedure 12b-6, the court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor. To support this argument, Lively's team cites the case of Gia Luo versus Sogo, Inc., a class action lawsuit that was filed in the U.S. District Court for the Southern District of New York. And the case was presided over, by the way, by Judge Louis Lyman, who is the same judge overseeing this Lively Baldoni case. So here you have this former employee of a Chinese technology company in 2019 alleging employment discrimination and retaliation. However, Judge Lyman granted the defendant's motion to dismiss the complaint, ruling that the plaintiff failed to sufficiently plead her claims under Rule 12b-6. So there are a few key takeaways from this ruling that are relevant here. First, as the plaintiff, you have to provide enough factual evidence in a complaint to back up your claims. Second, the allegations have to be specific enough. They can't be conclusory. In other words, you can't simply state that someone acted with actual malice without showing a little bit more, without demonstrating precisely how they acted that way. So Lively's team is arguing that Baldoni's complaint falls well short of this because it lacks specificity. They write in their filing, the FAC, the First Amendment complaint, does not assert a single defamatory statement attributable to Miss Lively, leaving Miss Lively to guess as to what to defend against. They further argue that the complaint jumps to the conclusion that Lively knew her allegations were false, which would constitute actual malice, an element for a defamation claim against public figures, but fails to specify how she knew this. The filing reads, yet another of the FAC's insurmountable deficiencies is its utter failure to allege actual malice. That is, that Miss Lively subjectively did not believe the sexual harassment allegations that she raised. Other than many pages of empty bluster, the FAC not only fails to allege actual malice, it pleads just the opposite by demonstrating her good faith beliefs. And Lively's team also points out that Baldoni's complaint doesn't identify which of the plaintiffs was allegedly defamed, nor does it specify any defamatory statements made by Lively herself. That's the argument. They argue nowhere do the Wayfarer parties explain which of the 8 plaintiffs in this action was allegedly defamed, identify any purportedly defamatory statements made by Miss Lively, or otherwise identify any false allegation asserted by her that supports their defamation claim, leaving Miss Lively to guess at what to defend against. The claim fails for this reason alone. Additionally, Lively is arguing that Baldoni's complaint falls outside the statute of limitations, that under California Code of Civil Procedure 340C, defamation claims must be filed within 1 year of the publication of the alleged defamatory statement, meaning the statute of limitations would begin at the time of the very first published statement, and that essentially, in Baldoni's case, Lively is saying or arguing the time has run out, the statute of limitations has expired, because his lawsuit was filed more than a year after the alleged defamatory statements were made. How? Well, Lively argues that the statements that Baldoni is accusing her of making, she makes the argument they were first published in her 17-point list back in November of 2023, more than a year before Baldoni sued for defamation on January 16th of this year. So according to Lively, anything in Baldoni's lawsuit claiming defamation would need to stem from statements that she allegedly made after January 17, 2024 to fall within the 1-year statute of limitations. But Lively's team asserts that didn't happen here. The filing explains the FAC, for example, asserts that Miss Lively first conveyed her allegations via the 17-point Protections for Return to Production on November 9th, 2023, which was shared with both Wayfarer and Sony, although they admit she had raised some concerns as far back as May 2023. As early as November 2023, the Wayfarer parties believed the document to contain false accusations couched as demands that Mr. Baldoni and Mr. Heath engaged in sexually inappropriate conduct during filming. The FAC goes on to admit that during the January 4th, 2024 all-hands meeting, Miss Lively read aloud a list of grievances, including those in the Protections for Return to Production, as well as others, which again, the Wayfarer parties believed were fictional and had never happened or had been grossly mischaracterized. The FAC thus confirms on its face that Miss Lively published her sexual harassment allegations to Wayfarer, Mr. Baldoni, Mr. Heath, and others prior to January 17th, 2024. So basically, if you had a claim, you should have brought it then. It's too old. Now, Lively's motion also takes aim at the other claims leveled against her: false light, civil extortion, breach of the implied covenant of good faith and fair dealing, tortious interference, arguing that these claims fall short as well, starting with false light, which is basically the sharing of highly offensive false material. Lively's team contends that this claim is essentially duplicative of defamation, that it is not factually distinct, and they argue that since the false light allegations overlap with the defamation claims, they should be dismissed as a matter of law. Next, they addressed civil extortion, arguing that this claim fails because there are no allegations that Lively received any money or property as a result of the alleged extortion. The filing states the FAC does not even attempt to allege the basic elements of extortion, much less with the particularity required by the federal rules of civil procedure. Nowhere does the FAC allege that Ms. Lively obtained any money or property from the Wayfair parties, much less through a wrongful threat of criminal or civil prosecution made with knowledge of the falsity of the claim. So under Section 518 of California's Penal Code, extortion is defined as obtaining property or other consideration from someone with their consent through the wrongful use of force or fear. And Lively's team points out that Baldoni's complaint doesn't specify what money or property she allegedly received for extorting her way into editing a movie, which means the claim doesn't meet the legal requirements for extortion. And she also argues that this theory is based on her workplace harassment claims, and you can't sue over that. It's not extortion. Now, as for the remaining claims, breach of the implied covenant of good faith and fair dealing and tortious interference, Lively's motion argues that these also fail to meet the necessary legal standards. So importantly, Lively's team emphasizes that these claims are governed by California law and not New York law, which is significant because it allows her to invoke what I mentioned before, Section 47.1 of California's Civil Code, or at least try to do so, the statute providing protections against retaliatory lawsuits for individuals who speak out about sexual harassment. These are protections that might not be available in other states. So what is Lively seeking? Well, as I mentioned earlier, she's asking for the dismissal of the First Amendment amended complaint, the FAC, and for attorney's fees, punitive damages, and the like. And as we are discussing this, as we're discussing Lively's motion to dismiss, it is worth revisiting Ryan Reynolds' motion. As his filing, while similar in some respects, it takes a slightly different approach because while Lively's motion seems to heavily rely on what we've talked about, California Civil Code Section 47.1, Reynolds' legal team emphasizes that the allegations against him are not only baseless, but they also fall under the protections of New York's anti-SLAPP laws, which we talked about. That Reynolds' motion specifically addresses the claim that he called Baldoni, quote, a predator during a conversation with a talent agency executive. And his legal team argues that this statement is protected under the First Amendment. It is opinion. It is rhetorical hyperbole, a legal principle that shields exaggerated or non-literal statements from defamation claims. And the filing cites precedent cases where terms like scum or predators and greedy crooks were deemed non-actionable opinions, meaning you can't sue for them. Now, Reynolds' team also points out that Baldoni's own public admissions about his past behavior, or alleged admissions, including apparent struggles with pornography addiction and mistreatment of women, this is all evidence that the term predator is substantially true. And for context, Baldoni allegedly admitted in his complaint that he discussed his past pornography addiction with Blake Lively during filming, although he claimed it was because she had first shared with him that she had never seen pornography before, so that's why he said it. Now, one of the most intriguing aspects of Ryan Reynolds' motion is that there is a subsection, and it is titled, "The claims against Mr. Reynolds fail under both New York and California law." This is while Lively's motion says the parties agree that California law applies to all claims against Ms. Lively. So Lively's case seems to be applying the principles of California law, while Reynolds' team argues that the claims against him don't hold up in either California or New York law, and that there isn't necessarily clarity as to whether his case would be under New York or California law. But there is an argument that Reynolds' case should apply under New York law, and that this is based on the fact that the alleged conduct, such as the all-hands meeting at Ryan Reynolds' New York penthouse and the conversation with the talent agency executive, occurred in New York. Additionally, Reynolds is a New York resident, apparently, which further strengthens the argument that New York has a greater interest in regulating and hearing this case. Now, I want to shift gears, and I want to discuss some potential weaknesses in both motions. Let me rephrase that. Maybe potential counterarguments that could be asserted by Justin Baldoni's side. So Lively's motion heavily relies, as I've been talking, Section 47.1. Okay, we've talked a lot about it. The protection to bring forward these claims without the fear of retaliation. But I do wonder whether Baldoni's team could potentially argue that not all of Lively's statements fall under this protection, especially if some were made outside of the context of a formal legal proceeding. For example, if Lively's statements to the press were deemed part of a smear campaign rather than a good faith report or good faith effort to report harassment. Maybe they might not be covered by Section 47.1. Maybe you'll hear that argument. Lively's motion also argues that Baldoni's complaint fails to allege actual malice. Now, again, that is a necessary element for defamation claims involving public figures, meaning you knew the statement was false or you acted with reckless disregard for the truth of that statement. However, Baldoni's team could try to get around this by maybe arguing that Lively did know that she was making a false statement about what Baldoni allegedly did, that perhaps Lively's alleged demands for more creative control over the film point to not a real belief or assertion of her being harassed, but rather a weaponization of a false claim to get what she wanted. And I believe so much of this comes down to what can be shown about what actually happened on that set or in connection with the production. So I wonder if a judge maybe won't dismiss this and say, allow a jury to decide this, allow the fact finder to resolve this factual dispute. Now again, Lively's motion makes the argument, criticizes Baldoni's complaint for engaging in, quote, group pleading, which basically lumps all defendants together without specifying individual claims or actions. But Baldoni's team could maybe argue that the allegations are specific enough to put Lively on notice of the claims against her more specifically, and particularly since she is the primary defendant. And they might also claim that the group pleading doctrine doesn't apply here because the complaint provides sufficient detail about Lively's individual actions, such as the 17-point list and communications with others. Now, Lively's motion also argues that many of the alleged defamatory statements fall outside the one-year statute of limitations. We talked about that too. But Baldoni's team could invoke what is known as the continuing publication doctrine, which could potentially reset the statute of limitations each time the statements are republished. So the continuing publication doctrine has been addressed in several California cases. For example, in Shively v. Bozanich, the California Supreme Court held that the statute of limitations for defamation begins to run on the date of first publication, but subsequent republications can give rise to new claims if they occur within the limitations period. And this could make potentially some of Lively's statements timely if they were republished within the limitations period. And if Lively's allegations maybe were repeated in, news articles or social media posts within the one-year period before Baldoni filed his lawsuit, he could argue that the republication resets the statute of limitations. Or if, Lively or her representatives shared or discussed the allegations on social media or other online platforms within the one-year period, maybe it clicks in then. We shall see. That could be an argument. I'm wondering if that could be an argument. But switching over to Ryan Reynolds' motion, arguing that calling Baldoni a predator is protected opinion, you wonder whether or not Baldoni's team could counter that the terms imply factual assertions about Baldoni and his behavior, such as engaging in sexual harassment or misconduct. They might argue that Reynolds' statements, they were not merely opinions or hyperbole, but they conveyed defamatory facts about Baldoni's character. And Reynolds is arguing that this statement is protected by the First Amendment because it's the opinion of a person who truly believed that his wife had been sexually harassed. But Baldoni's team could argue that the severe implications from saying it, especially if untrue, and if he arguably knew they were untrue, allegedly knew they were untrue, that could end up being defamatory. So with the motions to dismiss now pending, the case is set to proceed to trial next year as of now. But if the court grants Lively and Reynolds' motions, Baldoni and Wayfair Studios, they could be on the hook for maybe a lot of money. Legal fees, damages, we'll see. But if the motions are denied and the case moves forward, this could result in a very high-profile trial that would expose the inner workings of Hollywood, the potential power dynamics at play in the entertainment industry, and maybe what really happened between these two. But that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.